SJC-13224 in the matter of an impounded case.
Okay, Attorney Hodge.
Good morning, Your Honors, and may it please the Court. My name is Kay Hodge, and along with my partner, John Simon, we represent the Massachusetts Interscholastic Athletic Association. I will refer to it as the MIAA. And I think I would like to start by just describing briefly to you what the MIAA is. It's a private membership association comprised of effectively every public school in the Commonwealth, along with some private high schools. It is a product of Chapter 71, Section 47, which authorizes school committees to band together in this way in order to facilitate competitive athletic events. As a private membership organization, it is the members that decide what rules should be applied, what those rules are going to be, and how those rules should be enforced. In furtherance of its goals, and its goals are important here, in furtherance of its goals to ensure fair athletic competition, equitable processes, and otherwise to make sure there's essentially a level playing field for everybody. They have created a set of rules, one of which is 59.1, which is the rule that's at issue in this case. 59.1 is a rule that says that interscholastic athletes get 4 years from the day that they begin the 9th grade, and it's counted consecutively. So you don't get to play a 5th year. The case that you have before you is a situation in which an individual sought a waiver of that rule. And there are waiver provisions, and the waiver provisions are contained in rule number 80, I think it's 87.5, excuse me, all these rules. But in any event, in that rule, it provides that a waiver requires 4 elements, or at least consideration of 4 elements.
Attorney Hodge, let me ask you, on the arbitrary and capricious standard that you urge us to adopt, how do we know, how does the Superior Court judge? So you get these motions all the time, and as we see from the briefs, you get different results. Right, okay. So how does the judge know whether the MIA applying the 4-part 87.5 standard is being arbitrary and capricious unless they know what the prior decisions of the committees have been? Are these decisions published? Are they accessible? I mean, because you really have to compare apples to apples and student to student in their particular situation. And unless they're published, how are they not one-offs?
I don't believe that they are one-offs, Your Honor. I think that they are very clearly.
Are they published?
They are not published, to my knowledge.
Okay.
However, they're internally maintained, and therefore, but the bigger issue is this.
Well, can you ask my littler issue?
Okay.
And the issue I've got is I'm sitting in Suffolk Superior Court, and some kid right before the big game comes up, and he's all set to go, and the parents are there, and the MIA's there, and I have to decide a motion, the PI. And that's really determinative because these cases rarely get appealed. And they say, this is the worst thing, this is arbitrary, this kid should get the waiver. And I say, well, what about like kids that are in similar situations, and I don't have that information? How do I decide what's arbitrary and capricious if I have no information, no foundation?
I think that the first question is, and this is no different than any other case that you would have in an employment arena or whatever, it is that you've got to look to see if there are similar situated situations, and I think that there could have been a request for information to MIAA. You know, they're the public entity, and therefore that request could have been proffered, and it was not in this case. But I think it's more important is this,
But
that
before
the
you leave
4
that,
standards.
Before you leave that,
Yeah.
I was just looking at footnote 10 in the opposing counsel's brief. It's a follow-up to Justice Gaziano's question. So how do they know? In the same conference, in fact, at least, this is according to the footnote, in fact, at least 3 of the athletes who were granted a 5th-year waiver played in the same conference as Austin Prep. One of the 5th-year athletes was widely considered one of the best players in the state, and was a serious contender for the most valuable player. Is that, to me, I have the same question Justice Gaziano has, which is, if that's was that introduced at the hearing?
Not that I know of, no.
But, so that becomes really significant, because seems to be the only way of judging whether something's arbitrary and capricious.
I don't believe that that's right. I think that what you have to do is focus on the decision that's in Record Appendix 144 to 146. It goes through the various criteria and the evidence that was presented and was considered. And I will point out to you that, number one, the review board is the EAB, or the Eligibility Appeals Board, is comprised of educational and athletic professionals. And they are a part of this organization and hear these cases on a fairly regular basis.
But that's a trust us argument that.
Pardon me? It
That's
is
a trust us argument, and
I
I
would
mean,
suggest that's correct, yes.
but isn't Justice Gaziano right that if this kid is the most valuable player of the year, and he's obviously taking time from other people, playing time from other people. I mean, I don't know anything about the facts of that, but if that's true, I mean, because I get you. I mean, when you look at those four factors, the impact on the school, the impact on the kid, clearly this kid is hugely benefited from being able to play, but some other kid isn't going to be able to play, and you can always point that out with a good athlete. You can always point that out with a very good athlete, that someone else is going to lose time. But I just don't know. I mean, if the most valuable player in the state gets a fifth year, why doesn't this kid get a fifth year?
Well, I'm not sure that that was established, and I don't know that the most valuable player, I mean, I understand that that is what they are asserting in that footnote. I can't tell you. What I can tell you is you have a written opinion. It is 3 pages, single-spaced, and it goes through and it describes the information that was presented. There isn't a lot of dispute except for these other cases, and they go to basically that there was no undue hardship to this individual because he played for 4 full years. You do not know in that other case, and I point out again, they could have obtained information under the public records request, but they did not. But you do not know whether or not in the other case the particular athlete.
Does your client do that, though? Does your client go into these hearings and say, here's 5 cases just like this kid, and they didn't get a waiver?
I think that in most of the instances, they are aware of the other cases. Do they actually mathematically line them up? And the answer is no.
But when you say they're aware, who's aware?
The members, in the first instance, the person who hears these cases is the executive director or his or her designee. And that individual is the keeper. The person who normally sits on these cases is the keeper of all of the decisions today. Now, over time, have those decisions changed? Yes, they have, and to the better. I mean, there have been a number of cases that have come through that have, refined how people have thought about disabilities and gender and a variety of other issues. So absolute and strict adherence to how we've done it always should continue to be true, shouldn't necessarily be true.
I'm just concerned about the kids that line up and they get disparate, same type of kid. One kid was bullied, another kid has another tragedy. One kid gets a waiver, one kid doesn't get a waiver. And I'm just really concerned about the arbitrariness of that. And it basically depends on which Superior Court judge roulette, which judge do you draw? Whether you get the PI or you don't get the PI.
I agree with you, Justice Gaziano, but I would also point out that in almost all cases, not all, but almost all cases, what you have is this 5th year issue applies only in the private school context. And the reason is, except for an individual who had to withdraw or voluntarily withdrew from school in a public school, after 4 years, and there is another rule, which is 61.1, I believe, or 62.1, which is a rule that says after you have accumulated the credits to graduate, you're considered a graduate, unless you're in the middle of a sport. And the fact is you cannot then play more. So the public schools do not offer a student an opportunity to stay over for an extra year. And consequently, this is an issue of some level of fairness. The other point I would make, and that was why I started with telling you about the MIAA, it is comprised of people who are all members and have chosen to be members of the association and have decided that these are the rules and have decided that the EAB will be the methodology by which those rules will be applied. And it is in that context. In the same way as you do not know if an agency, all of the agencies that make determinations, and there are a number, we cite a number of cases that are somewhat similar, where discretionary decisions are made by an agency, and an agency then proceed and then are subject to the arbitrary and capricious standard. The question is were there enough facts that a reasonable person would have agreed with you, with the decision that was rendered? And the facts are listed in the decision. What you have instead is you have a judge who, in that context, it's a discretionary agency decision which is coming before him, decided ab initio to hear the facts and make a different decision. Now, in every case, there are likely two versions of those facts, or how you infer. This court has said repeatedly in these cases that it is not for the Superior Court to revisit the credibility, to make different inferences, even if you would have made a different decision. And what you're basically saying is that we will require of this association that they then impose essentially, what we as lawyers have, which are, compendia of cases, et And I'm not sure that that's the appropriate standard in this instance. And I understand that for some of you, sports matters a huge amount, that athletics are really important. And I understand that to a parent, it is perhaps the most important issue of the moment. However, the fact of the matter is this is a discretionary agency decision that was being reviewed by the Superior Court judge. And I would also point out, if you read the brief, well, you do read, the brief of the appellees, plaintiffs' appellees, the fact of the matter is they repeatedly state, well, there was enough evidence in the record to support, or look at our pleadings and they support the decision of the Superior Court judge, which is not at bottom. When you're looking at whether or not there's a substantial likelihood of success on the merits, you have to look at the decision itself and what is in fact presented. Now, I hear that there are refinements that the MIAA can consider, but as a body corporate, they can decide whether to do that or not. Or you will say, this is an agency that we're going to pull to the side and have a whole different set of requirements for essentially discretionary decisions. And I would urge you to consider that we ought to apply the same
I think
legal
you're right that they've identified the exact right standards to look at. The problem is they can come out, unless we know how they apply it to anyone else, they can come out, I mean, if you apply those standards, you can come out however you want. Both, there's almost, one thing look at the impact on the kid, one thing looks at the impact on other kids, one thing looks at the conference, one thing looks at the entire system. All good factors, but the only way you can judge whether something's arbitrary or capricious is whether they apply it evenly, right? I mean, you're an employment lawyer. You know that that's the measure of equality is, do you apply it the same way to the same people, right?
Well, I think that may be right, but that is not heretofore been the standard, and I suppose the legislature could have decided that it shall be decided in this particular way. I think the members here have decided that the criteria shall be, they do in fact relegate the decision to a group of individuals who they trust, educational and athletic professionals, who make up the EAB to apply the standard in an equitable and appropriate manner, recognizing the constraint that I had just mentioned to you, and that is that the fifth year is not available to everybody. It's available.
Can a judge ever reverse one of these decisions?
I'm sorry, what?
Can a judge ever reverse one of these decisions?
Ever reverse one of these decisions? And they have.
I know, but properly, in your view.
Well, the fact of the matter is I would suggest that the standard of arbitrary or capricious, or at least the way I was taught, all along is it's a very, very high standard. And the
No,
fact that
I agree with you, but suppose, give me a parade of horribles. You have these four standards under 87.5. The EAB has written, and it's a fine decision. I'm not, I think it's supported. But I'm just wondering, when are they ever wrong? And how is that not arbitrary and capricious if they're always right?
Can I tell you that
How is there any meaningful review?
there are very few instances where the fifth year is or should be allowed, because the very rules tell you that the membership had decided that 4 years is it. This individual had 4 full years, which is probably one of the biggest weighing factors in all of the consideration. He played 4 years of basketball, 4 years of football. And the issue of, quote, bullying, which is serious, and I don't want to minimize it, but the issue of bullying was considered, as was the psychological report that was proffered by the parents on behalf, and, you know, in this case. I would suggest to your honors that, again, I would cut the slack to the individuals who are making this decision on the EAB. And I would also point out that the record evidence is that this individual got 2 EABs. The first EAB was canceled, if you will. It was a unanimous decision denying the waiver, but because one of the individuals on the panel had to leave abruptly, therefore, they gave him yet a second full review. If the requirement is going to be that there must be that evidence, then in fact, you know, that would be something that the MIA will have to consider. But I urge this court to consider that I believe that the decision is supported, as Justice Cassiano suggested, is supported by substantial evidence, in fact. The fact of the matter is the injunction should not have issued, and indeed, if it was going to issue and going to overturn the decision of the EAB, it at least ought to have described why it was doing what it did. And finally, I would urge that this court look at our brief with regard to the issue of mootness, because it is our view that because sports seasons are what they are so short that we need to get some clarity, because the number of these cases is rising, as are the number of cases, and we expect that many will come if the COVID issue is considered to be an overwhelming part of this decision. And so all of these factors I ask this court to consider, and I ask you to reverse the decision below. Thank you.
Thank you very much. Attorney Hamilton.
May it please the court, my name is Andrew Hamilton, and I represent the plaintiff appellees in this matter. There are 2 reasons why this appeal should be resolved in favor of the plaintiffs. First, this case is moot, as the student plaintiff has completed his high school career and high school athletic career. And
Is it moot as to Austin Prep?
I'm sorry?
Is it moot as to Austin Prep?
Yes.
Why?
And the reason why is because there's no further relief that's being sought by either party. And so,
But can you address Attorney Hodges' point that this is capable of repetition yet evading review in light of the length of the seasons inherent in these sports?
yes, certainly. So we don't believe that this is a case that's capable of repetition.
Well,
because,
not for this particular person, but for all the other student athletes who want to play in their 5th year.
Right. And so I would look at that as part of it is capable of repetition. The other part is evading review. And so the exigency that the MIA brings up is their issue, something that they control. So the MIAA is the one that sets up this whole procedure for athletic waiver. They're the ones that set the deadline for when the applications are due for waivers. They're the ones who set up the appeal process. They're the ones who set it up so close to the first game of the season. And then in this particular case, when we get to the litigation, there are a number of ways that the MIA could get an earlier decision on this case, a decision on the merits. So, for example, they could have under Mass Civil Procedure Rule 56, they could have sought to combine a final decision on the merits with the preliminary injunction hearing. They didn't do that.
I mean, I agree with Justice Gaziano. Effectively, the PI is it. So, but that doesn't answer why we shouldn't go ahead and answer this question that will inevitably come up again in the future.
So, again, I think that there are other ways that the MIA could have gotten a decision, but you know.
So tell me why you went on the merits.
Why we went on the merits? Certainly. So the reason why we went on the merits is because the court, the EAB has, in its decision, ignored important facts, contrary evidence to its decision that simply weren't considered. And a reviewing judge, in this case Judge Doolin in the Superior Court, could have looked at those facts that weren't addressed by the EAB and found that we had a substantial likelihood of success on the merits. And we believe that the judge...
So he would have to find that there was a substantial likelihood of success in the merits, that the MIAA acted arbitrarily because you presented opposing evidence that didn't end up in the written decision. That's what you're saying?
Yes.
Okay. That sounds like a substantial evidence standard, and I thought you agreed that it was arbitrary and capricious.
So for a point of clarification, we haven't challenged the arbitrary and capricious standard.
This was the time.
And the reason why we did that is because this is the decision that the Superior Court came up with, and obviously it came out in our favor, and we believe that we can win under the arbitrary and capricious standard. And so you asked for what the reason is that we think that we win. And there are a number of facts that are provided in the briefs, and I can go through those.
But their standard is so open-ended, and the factors they're considering seem legitimate. I thought it's a very good decision. If it weren't for your footnote, I'd say, wow, that's a well-considered decision, particularly what Ms. Hodge just emphasized, which is they emphasized at the last point that he's played for 4 seasons in both sports, which is unusual. I mean, he must be a very talented athlete. But the only thing that gives me pause is this fact that, again, an MVP in the same conference. Was that presented to the judge? Does he have, or is that something you guys came up with afterwards?
No, Your Honor. That was presented to the Superior Court on the motion for reconsideration. It was in an affidavit by the Austin Prep Athletic Director. It's provided at Record Appendix 197. So the judge did have the ability to review that in its
But when he makes his
motion to
original decision, which has no analysis,
I'm sorry, Your Honor?
it has no analysis, the original decision.
Yes, Your Honor.
But secondarily, he's given this, and are the facts of this MVP presented that he actually had 4 years of eligibility prior to that, and he played for 4 years? Is that in that affidavit? I haven't read it.
So I could pull up the affidavit. I believe these were all fifth-year waiver applications. So
Meaning, when you're a fifth year, does that mean you played all 5 seasons? I mean, all 4 seasons, or does that just mean you were eligible to play all 4 seasons?
So for the as I read the MIAA regulations, it doesn't matter. So if you start, it's 4 years from when you started. So even if you don't play any of the 4 years, you still have to apply for a fifth-year waiver if you want to play your fifth year.
And in the hearing, and again, I haven't read this whole record. We don't have a transcript of the hearing, or we do have a transcript of the hearing?
Yes, Your Honor. We have transcripts of both hearings, and they're included.
Okay, so they're in the record. And
appendix.
do they talk about comparisons, that kids have been allowed to do this, they've not been allowed to do it, or is it just a general sort of discussion of this particular child?
So the
Go ahead.
Sorry. So the decision and the discussions in the transcript are about this particular student. And Your Honor raised this issue on my sister's argument, and it's a valid point. How do we know whether this is arbitrary and capricious when we don't know how the other the other cases have gone. We have some evidence presented in this affidavit, but we don't know. And-
Counsel, if I can interrupt you, that's really not going to advance the ball downfield, so to speak, because you just don't know anything about those other applications, and they could be very different. When you're talking about the makeup of the team, the impact to the other players, all of these things are going to be very different. So just looking at this particular application, and again, I don't mean to suggest by my questions that I'm minimizing what he went through at the first 3 years of the institution where he was at, but all of these things were considered by the board. And it seems to me that this is a substituted judgment question here as to whether or not somebody else would have done something different. But under the arbitrary and capricious standard, if you read that decision, which I did, and I delved into the record quite deeply, why isn't this supported and it's just you don't like the decision they came to?
No, so thank you for that question, Your Honor, because I don't think that this isn't a situation where we say we don't like this decision and so it should be overturned. This is a situation where we've presented evidence that we don't believe that the EAB has considered.
Like what?
It doesn't address, so the first one, and the most important one, is the documented therapeutic benefit that competing in this season, or these 2 seasons, would have in the student in light of the mental and
But that
emotional woes she suffered.
wasn't that in the social worker's letter that was submitted?
It was, Your Honor.
And
yes.
didn't they cite that they considered that in the decision?
They cite that letter, but they cite it for the proposition that his academic difficulties were a result of COVID. They do not get into this issue of the therapeutic benefits that competing has.
Well, it goes back to Justice Wendland's point, though. It may not have necessarily been articulated by the board, but the letter itself was submitted. It's part of the record. They reviewed it, and they referenced it in the decision. At one point and I believe it was your brief, you made reference to a high school athlete can only play in high school. And going back to Attorney Hodges' point, he played 4 years of football, 4 years of basketball. He got a high school experience of playing sports, in both sports. So I'm going back to the likelihood of success on the merits, where everything that you laid out in your brief, in your motion, was presented to the board, and the board didn't find it compelling enough to issue the 5th-year waiver. So again, if you could crystallize and point to me directly, what is it that they didn't consider in those 4 factors that would have tipped the scale to say that, again, a substantial likelihood of success, not just a likelihood, substantial likelihood of success?
Yeah, and so this therapeutic benefits is one of them, and it goes beyond just his he had a high school experience. This is something that's going to benefit him, the student, not just this year, but as he grows up and continues into adulthood, where he has a chance to work through this incredible emotional and physical abuse he suffered at his previous high school. And there are a number of other aspects that the court, that the EAB didn't consider. One of them was brought up by one of your colleagues, and I apologize, I forget which justice, but the issue of playing time. And so the EAB said, and it's done this in a number of decisions where it says, well, the fact that a student is competing on this team automatically means that he takes the varsity position of another student. In this case, we presented evidence to the EAB that did not make it into the decision, but it's in the record that Austin Prep, for both of these teams, didn't have enough, had trouble filling the team roster.
Well,
And
so it's complicated, and I guess I'm guilty, when I was the Superior Court judge, of substituted judgment, perhaps, sometimes when I should have been doing abuse of discretion. But, school sports are important to lots of people who've been bullied, and lots of people who have suffered through COVID and worked weekend after weekend after weekend, and all they got was a shortened season. it's not how many players are on the team. There's a sixth man on that Austin Prep basketball team who was the sixth man instead of starting. So what's so different here? I mean, the bullying, the mentor who is a coach, every one of these has a compelling story if they're coming back for a fifth year. You know, they're usually not coming back for a fifth year because, well, they loved high school and they loved sports and they just want a fifth year. There's usually a compelling reason.
So I think that there are a number of cases where there is not these kind of situations where it's not just, there are applications from students who simply want to be able to compete for another year. And they're great athletes.
And those go to Superior Court on Friday afternoons?
I'm sorry, Your Honor?
Those are the cases, those cases don't seem to get as far as Superior Court on Friday afternoons. The ones I had were not, oh, I just think I wanted to be it. They were reasons that were pretty darn good reasons.
Yeah. And so, but this, I think this situation is different because it's not just that he wants to compete, that he wants to play a sport. It's that this has a important ancillary benefit to him. And so that, I think, separates
And
it
nearly
from,
everybody else on the team.
I'm sorry?
And nearly everybody else on the team.
Sure.
So the record shows that he's a strong player, but his participation in this team, you know, didn't tip the ball in anyone's favor. The team didn't make any championships, hasn't won any titles, and so he's a good player, but it hasn't tipped the favors in any particular direction.
Maybe, perhaps not, you could make the argument not to his team, but certainly you could make an argument that to an opponent playing someone who's a year out of 4 years, a year physically more developed, certainly in terms of the abilities, they only get better with experience, not worse. So what if the MIAA or the EAB just said, this is what we want a level playing field, we want apples to apples. To the extent that we can. So again, I go back to, I understand you can make compelling reasons for all the therapeutic benefits, but what if another applicant, again, is back to Justice Gaziano's point about, well, somebody had a tragedy that year and a death in the family, or they had some other thing that preyed on their mental health. They could make as compelling an argument. And what does the MIAA do with all of that? In this case, they considered that and made a determination that waiver was inappropriate.
Right. And they can certainly make that decision, but it has to be supported. It can't be arbitrary and capricious. So and so in the case where a student has died, a family member has died, I think that would be worthy of a waiver. And to your question, well, the MIA doesn't have to set forth a waiver application. If it's so concerned about fifth-year students competing against students who haven't had 5 years, they could just get rid of the waiver application altogether and just say, this is the most important thing to us, is having a completely level playing field. So there's no waiver. You got 4 years, and after that.
But then wouldn't you be arguing that that was arbitrary?
Well, so if if the procedure applied to everyone equally, no one gets a waiver ever. There's no. I would find that hard to be arbitrary and capricious.